NACDL is the association of the nation's criminal defense bar.
But I think most of what we're going to talk about is easily transferable to the cross-examination, really, of any drug agent. There's a lot of task force now, and we know that this comes up just more and more and more. So today, while we're talking to you, we're going to talk about, and I want you to imagine a government agent being on the witness stand, and really how to make your case through that drug agent. All right.
So these are your defense goals when cross-examining the drug agent. First, it's to admit the affirmative facts in your case, those facts that are helpful to your defense. You also want to undermine the cooperator's credibility. You may have a CI or a CW in the case. Highlight the inconsistencies between various witnesses' testimonies, and question the reliability of the investigation. These are all goals that we're going to cover in the next few slides.
So what we really want you to do is feel prepared to hijack the government's agent to become your own witness. And we want to start with a little vignette that actually occurred in a federal drug case, the short cross-examination that actually was the one done by the lawyer in the case. What you need to know about the case is that the lawyer represented an offloader, meaning somebody who was hired to transfer bundles of marijuana from a panga boat. A panga boat is a small outboard motorboat that's kind of designed to bring a lot of marijuana from Mexico to these small coves off the coast of California, quickly gain shore. A crew of offloaders will come in, offload the marijuana, put it in a van, the van will drive away, and everybody disperses. So this was the cross that the attorney did of the drug enforcement agent whose name was Agent Hart in the case. Meghan will play Agent Hart. Agent Hart, you testified on direct examination about several photographs, correct?
Yes.
I'm showing you government's exhibit number 1. If I show you this photograph and I ask you to look at the boat in the photograph that came up on the beach of that cove, you would have a belief just from that look of that boat as to what might be in the boat, right?
Yes.
And what would that be?
Marijuana.
And why would you suspect marijuana simply from that type of boat coming up on the cove?
Because typically in past investigations, where I've handled items off boats like this, the bundles have contained marijuana.
Now, if we look at the bundles we can see in the photo agent, we can see that they're bound with baling wire around black plastic wrapping, correct?
Yes.
And in addition, taped around the seams, the edges of the plastic, right?
Yes.
With your naked eye, you would not be able to tell the content of the packages, correct?
Yes.
But as an expert, as you are, with a number of past investigations, you can tell us, because of your experience in the field, what you thought was inside, right?
I can tell you what I think it is.
And that's based on your experience, right?
Yes.
Well, look at this photograph, exhibit 2. Do you see canisters, large canisters in the boat?
Yes.
And do you have an opinion what might be in those large canisters?
I do, fuel.
And that opinion, again, is based upon your past investigations of panga boat cases, correct?
Yes.
And approximately how many have you personally been involved in?
About 15.
And how many have you been involved in as a team with other investigators?
About 40.
In any of those past investigations, were you immediately able to smell gasoline as you approached the boat?
Yes.
And that's because the trip on the ocean is long and bouncy, and the gasoline they use gets sloshed about as they move it from jars to the engine, right?
Yes.
And why, based on your training and experience, are there so many multiple layers in the packaging?
To keep the product dry.
and also to keep the smell concealed, correct?
Yes.
And because that's one of the goals of the drug dealers, is to keep the marijuana smell from emanating, right?
Right.
And you know that based on your experience as an agent, right?
Yes.
Now, you testified on direct about the range of payment for these offloaders. The people who move the bundles being between $200 and several $100s. Is that right?
Yes.
And that's based on your experience, correct?
Yes.
And you testified on direct about the value of the marijuana in those bundles, right?
Yes.
And that was based on your experience, right?
Yes.
Now, these opinions you collected, not because you're a hobbyist, but because you're law enforcement, right?
Yes.
And the opinion of those values was based on many sources that you have available as a law enforcement officer, including talking to other law enforcement officers, right?
Yes.
Going to trainings, right?
Yes.
And based on your knowledge and experience from interviewing people you've arrested, drug dealers you've arrested, right?
Yes.
And these are things that are available to you as a law enforcement officer, right?
Right.
I have no further questions. Now, with that cross, you would be able to argue to the jury that your client, who's not a law enforcement officer, was not privy to all these sources of information, was not privy to these past investigations. So all this knowledge, essentially, you've built up his expertise, which he's going to be fully willing to build up. And you use him as your own witness, essentially, and then argue later on. But in comparison, my guy was, a high school graduate who's working, wherever he's working. Next.
And so how do we get to that point where you're able to execute an effective cross-examination of the expert or the DEA agent? Just like with any other witness, preparation is key. You need to make sure that you have everything you're entitled to receive and everything that you need to be effective. Now, unlike other types of fact witnesses, discovery related to many federal agents, including DEA agents, are not going to necessarily be produced in the first couple of rounds of discovery that you receive. They're not going to be produced in the general disclosures that you receive. Instead, discovery related to DEA agents is going to be guided by a few federal principles. First, we have Brady, Giglio, Bagley, and Youngblood. Those are seminal Supreme Court cases. They outline obligations imposed on the prosecution both in federal court and in state court. If you don't know those cases or haven't read them yet, you absolutely should. Federal Rule of Criminal Procedure 16. That outlines what the prosecution is required by law to provide in relationship to any expert or DEA agent who's testifying. Now we have the Jenks Act. The Jenks Act is a federal law, and it says that after any witness that is called to testify in the prosecution's case in chief, after their testimony, the prosecutor is required to turn over any statements that that witness made to defense prior to cross-examination. In the context of a DEA agent, or really any federal law enforcement agent, that means anything that that person has written down, any report that person has made, any emails or communications that that person has put down in writing and made to anyone concerning the case or his testimony. We have USA manual. This is public. It's a public document. You can Google it and find it online. The sections you want to look at are 9.5 on. Those outline DOJ's policies concerning discovery. We have the Ogden Memo, which is a memo from 2010 that was written by the DAG at that time. The Ogden Memo imposes on prosecutors, federal prosecutors, obligations that federal prosecutors preserve certain information that may be discoverable, but more importantly, it imposes on prosecutors an obligation to do the research themselves. They need to go inside of case files. They have to themselves look at CI files to make a determination about whether anything in those files must be turned over to the defense. So they can no longer shirk onto agents or local officers or other members of the prosecution team the obligation to go through the files. And then lastly, check your office's local Henthorne policy. Henthorne are going to be any hit that you might get that is retained in a database concerning acts of dishonesty, anything that bears on a person's credibility that you're entitled to receive prior to trial.
And Henthorne is the name of the case it comes from, which essentially entitles you to find out acts of misconduct, acts of wrongful doing. You might have a fight over whether you're only going to get sustained acts as opposed to allegations, but the first step is for you to demand it. So now we're going to talk about how to use the agent and how to get prepared for the part of a cross if you want to use the agent to talk about the informant. How do you identify potentially discoverable information that relates to this agent's testimony as pertaining to informants? What promises? You need to demand what promises were given to this informant. What undisclosed credibility problems may there be? You're not going to know unless you ask. And by undisclosed, we mean you're probably not getting this in your initial rounds of discovery. You're probably not going to get it unless you ask for it. But ask about credibility problems of the informant. Payment details. You need to ask for how much was the person paid and when, and the documentation of those payments. You're going to try to develop evidence of entrapment. You want to know, did this informant, did this cooperating witness offer money, make promises to your client, take advantage of any undue weaknesses of your client? You want to find out and be prepared for them to call the agent to corroborate informant information. A lot of times, the informant is saying, 100 things, about 95 of which are uncorroborated. And the only things they can corroborate are usually things like the controlled buys that they observed. But they can't corroborate any of the unrecorded conversations. They can't corroborate meetings that they weren't participants at. All the other stuff, the informant was out there doing when the agents weren't watching. And evidence obtained during the investigation. Obviously, you want to ask about this. This is all in preparation, because you really cannot do a good cross unless you have everything, and then figure out, like Nan was talking about yesterday in her talk, where are the nuggets? Where are the little things that I can make from a molehill into a mountain? So, what information should be in the CI file? And in our materials, which are printed in your books or on a disc, however you got it, we included sections from the DEA manual. Now, the DEA manual that we got our hands on was a 2002 version, which may sound old, but they don't change that much. If you can get your hands on a more recent version, please send it to us. But there's great stuff in there about what must be in a CI's file. What's going to be there, and what does the DEA manual tell you is going to be there? The agreement between the CI, the confidential informant, and the agents. Criminal history of the informant. Any and all payments, rewards, subsistence payments, fees and expenses, payment dates, and documentation of that. And that's what's going to be so powerful for you to use on the cross. And you can get the agent to lay a foundation for these documents, because the agent, there is a controlling agent. You need to find out from the government who's the handler for that informant. But these are government records, and there should not be a dispute over the authenticity of them. In the informant file, you'll find out, was the CI deactivated? And that's important because one of the grounds upon which a CI can be deactivated is because there's a credibility problem, because there's something that happened, made the agents no longer believe the person. Also, 5K agreements, that's the federal lingo for a downward departure if the informant was actually prosecuted. And any other promises, you need to demand this kind of thing, whether it's in the file or not. What else did the agent say to the informant about, were they going to put in a good word at the parole board? Were they going to put in a good word with the immigration judge? Any of those things, because they're all incentives for that informant to say what the agents want them to say. So we're going to give an example to you of a cross-examination of how you would use this documentation in one of your cross-examinations of an agent. Megan's the defense attorney, and I'm the agent.
Now, when you first met CI4, she was housed at county jail, wasn't she?
That's right.
And that's because she had been charged with fraud.
That's my understanding.
And you and a group of agents, you had CI pulled from her cell, taken into an interview room, and there you convinced her to begin working with you, right?
Well, we asked her if she'd be willing to work with the DEA.
And this is the agreement that you made her sign.
That's the agreement she signed.
And after she signed this agreement, you had CI4 released from jail, right?
Yes.
And she immediately began working for you, pursuant to this agreement.
Yes.
And 3 days after you got her out of jail, you asked her to set up a buy with an individual named Mr. Smith.
Yes.
But you weren't present when CI4 first spoke to Mr. Smith about purchasing narcotics, right?
Right.
And her initial conversations with Mr. Smith, those weren't recorded, right?
We recorded the actual transaction.
But you did not record anything that happened leading up to the transaction.
Right.
And after that transaction was complete, you paid CI4 $1,600.
I believe so.
And this receipt, this is what you gave CI4 after she completed that controlled buy.
Yes.
And this is a government document that you keep in your file, right?
Yes.
And in total, CI4 earns over $40,000 the first year that she began working with you.
Well, I don't know that figure off the top of my head. It could be right. I'd need to check the file.
Well, here are copies of all of the payments you made to her. These are your official records, aren't they?
Yes.
And they total over $40,000 made in payments from you to CI4.
If you say so.
And on top of all of those payments, you also promised CI4 that you would have the state fraud charges dropped as long as she continued to successfully work for you.
Well, it's my understanding that she hoped her case would be dropped.
And that's because you told her that you would talk to the local DA on her behalf and ask for it to be dropped if she continued working for you.
Yes. And those are actually the facts from a federal case. So these are very real examples of what you can do with this material. But there's other information you could get in advance to help you maybe develop a different kind of cross of the agent. And next we're going to talk about all the electronic communications you need to demand in your case. Now, communications can come in so many forms now. And you have to be vigilant in asking for each category because the prosecutor really has no interest in going looking for things. But they'll have an obligation if you make the demand. It's another good reason to put things in writing. A lot of things can just be put in writing by email now. There's no reason not to do it, but you want to keep a record of it. And Meghan tells me that the U.S. attorneys have to keep and are not allowed to delete their emails.
That's right.
And I think the same is true of voicemails.
Yeah, so voicemails should be transcribed. When you send a voicemail message to a prosecutor, it's actually transcribed and sent then to that prosecutor's email account. But emails should be kept on a major server. the head of a U.S. Attorney's Office has the ability to go into that server and retrieve any emails sent. They are never deleted. The same goes, just so you know, with DEA agents, as well as FBI agents. They have their secret server, which is really tough to get to, but you can. And then they have their not-so-secret server, and that's the server that they use to communicate with outside agencies. Everything, though, that is put in writing on any of those servers, that is maintained indefinitely.
So I guess the message is be careful what you say, too.
Yeah.
But at any rate, they have to keep their emails of communications from their agents, and they have to keep their emails of communications with witnesses, voicemails, things of that nature. So if you get answers like, oh, I don't know, or those things don't exist, you need to press. So what should you ask for? Obviously, reports and memos. Don't just assume that in the discovery they give you, it's all the reports and memos. Ask for all the reports and memos. Emails, like we've talked about. Text messages. A lot of times agents communicate with each other, with their witnesses, with the AUSA, by text. And you should be entitled to the written documentation of communications in a text message as well. Instant messages, WhatsApp or other app platforms, voicemails, social media. Hopefully the agent's not on social media, but informants might be. And they might be communicating about this case, and the agents should be keeping track of and watching over their informants. And so make the demand of any communications the informants made. This extends to personal devices of the agents. So ask about work phones, ask about personal cell phones. I just had this issue arise in a case where we were heavily litigating a motion to suppress that they were fighting. And when we started asking about all these categories, we found out that they were using all these means to communicate with each other out on surveillance. And it was much more helpful to us than not getting that information.
And remember, this extends to personal devices. I had a case recently where the prosecutor told me they had no way of ensuring that information on an agent's personal device was going to be disclosed, and that they had no way of forcing that agent to bring their personal device into the office to review. So we asked to voir dire the agent before the agent testified, and the court ordered the agent to bring his personal device with him and ordered the prosecutor not to notice the agent of the fact that he was going to be voir dired on the text messages on his phone. Now, there's also evidence that's typically undisclosed in a case. And what do I mean by evidence that's typically undisclosed? I mean information from other investigations. Think of a DEA wire case where you have wires all over the country, right? But the information that's disclosed relating to your client may only be information from part of that bigger, larger investigation. Think of T-stops, where agents are trying to stop you from getting into information that's led up to the arrest of your client. Information derived from investigative leads. So you have these anonymous tips that are made to law enforcement officers. Or information from related investigations, where you will ask for information that maybe you see a reference to in one of your reports, and you're told, I'm so sorry, I can't give that to you. It would jeopardize other active and ongoing investigations. Those are types of information that is typically undisclosed, but that you should ask for.
So Megan, how would you recommend to people if they get an answer like that, oh, we can't disclose that, that's about some other ongoing investigation? How would you recommend people proceed?
First, put it in writing, like everything else. You're not gonna get it unless you ask for it, and you ask for it in writing. If they don't give it to you at that point, ask to have it disclosed pursuant to either a confidentiality agreement or a protective order. Then there's no risk of that information being disclosed to other people and jeopardizing investigations. If you still don't get it, make the discovery motion. Ask a court to review those communications in camera and have the judge make a determination about whether you are entitled to that information in your case. And then lastly, If you don't get the discovery that you think you're entitled to and you're going to trial, file motions to preclude the prosecutor from introducing any information relating to the other investigations or other leads or information that you haven't gotten. File the motions in limine to preclude. If the prosecutor then tries to bring it up during trial, file a motion for mistrial. File a motion for a jury instruction. File a motion for a limiting instruction. And at that point, because you've made your motions in front of the court for discovery, because you've made your motions to preclude the prosecutor from admitting that information, you are in the best position you can be to get the judge to act in your favor once the prosecutor tries to bring that information in. And in my experience, they usually do. Okay, so rough notes. That's an area where we get so much pushback from the prosecution. Now, I can tell you in Los Angeles and I think Southern California generally, the local federal policy is to disclose rough notes of a defendant's interview. So if an agent interviews your client, post-Miranda interview, whatever, interviews your client, you are entitled to rough notes of your client's interview. Check your local policy, though, to see whether that is the same where you are. Now, regarding other witnesses, DOJ policy mandates that agents keep indefinitely the rough notes of any witness's interview. And then beyond that, the prosecutor has an obligation to review all of those rough notes. So if Jenks applies, if a person is testifying, right, and there are statements that are directly attributed to that person, you have grounds to get those statements and the rough notes disclosed via the Jenks Act. Similarly, if an agent is the person who is interviewing a witness, the rough notes that the agent took down of that witness's interview, that's subject to Jenks, and you should get copies of that prior to the agent taking the stand in cross. So go through all of the reports that you get, see who authors them. If any of those agents are called to the stand in the prosecution's case in chief, demand all of the rough notes pursuant to Jenks. Now remember, even if Jenks isn't required, there may be other reasons that you're entitled to the rough notes. Perhaps Giglio or Brady applies. There could be impeachment or exculpatory information in the notes that means that you are entitled not just to that information, but sometimes to the production of the notes themselves. And as I mentioned previously, DOJ policy does mandate that all agents keep their notes. So even if you're dealing with a state case, but the people who investigated the state case are federal agents, they are bound by DOJ policy to keep the rough notes of any interview that they've done in the case.
And a lot of times in these rough notes, you're going to find those nuggets. It may be an inconsistency that's not apparent from a written report, because the written reports are really written to make you think your client's guilty and to make everybody plead out. So the rough notes are the places where there's going to probably be inconsistent statements or maybe things that the agent just didn't want to include in his typed report. What about identifying information about agent misconduct? Because the dirt on someone is the great place to be able to maybe show that there's some weakness in the prosecution's case. Giglio, Henthorne information. What is that? We've talked about impeachment information with respect to informants. You can also impeach agents, right? If an agent is willing, and Henthorne, as we said before, is the name of the case that entitles you to the misconduct information of the agents. If the agent's willing to break policy in another instance, why wouldn't he be willing to do it here? If an agent's willing to write a false report or willing to not book something into evidence or whatever the former misconduct was, why should they not have done something wrong in our case? That's the logical argument. Demand the information, the Henthorne or misconduct information on the agent in writing, and you want to demand it broadly. You want to demand any evidence of misconduct, any evidence of instances of prior problems with credibility, any prior instances of something wrong in a case with the booking of evidence or the processing of evidence or the interviewing of a client. I mean, you could think of a million different ways in which misconduct could be shown. Again, you want to ask the prosecutor to personally review the agency files, because these prosecutors, they love to delegate these responsibilities to someone else, and then they end up not really knowing what it was reviewed for, how it was reviewed, whether there was anything in there, what determinations were made, because there's so many subjective determinations that get made along the line. But at least your prosecutor has an ethical responsibility and is going to care about their career. It is, of course, hard to find out what you don't know exists, right? So at some level, you're always stuck with someone's subjective review, but I would rather that be by the AUSA on the case than by that AUSA delegating it to a DEA administrative person or a paralegal or someone else. So make your Henthorne motion to the court if you don't get anything from the prosecutor. A lot of times prosecutors, because you file a motion, will file a response, and you'll learn more in the response than you ever otherwise would have learned. Sometimes you learn in your response that they're filing something in camera, but the judge isn't really going to know how to review the evidence, right? The judge isn't necessarily going to have the context for your case. And so I think you want to push for some kind of a proceeding where you in camera maybe get to explain to the judge what it is about misconduct that you'd be looking for and why it applies to your case and why the credibility issue is such an important one. So more dirt that you can go out and get for yourself that you don't have to rely on a prosecutor to get.
Be a sleuth and do your own research. Google the agent's name. You'd be shocked at the information that you'll find. I had a case recently where an agent, I believed, had used excessive force against a client. Sat down, typed his name into Google, and what do you know? A local newspaper had picked up on other cases where the same agent had used excessive force, provable excessive force, against other people. Ask around, ask other defense attorneys. I get a ton of information from people who are in custody. They all talk to each other. My clients come to me with stories of Henthorne hits for agents that are involved in my case. Ask around to everybody that might know either the agent, know the agency, or has prosecuted or defended regularly in that district. PACER, for those of you who don't practice in federal court, PACER is an online database or program that's used both to file and also to look up case information in federal court. Use PACER to look up both criminal cases, civil cases, and bankruptcy cases. You'd be shocked at the type of information that you're able to find in bankruptcy cases. How is the agent spending the agent's money? Are there other allegations that have been made against that agent? Have you found a dissolution of marriage filing related to that agent? What were the allegations that the spouse was making against the agent? Look up everything you possibly can. Pull local documents when you can. Westlaw, FindLaw, LexisNexis. Do a search of your agent's name, first name, last name, special agent, last name. Do all of the different variations that you can think of your agent's name. See if they've been overturned in other cases. Maybe it's not an issue of misconduct, but have they done other things that were improper where a court of appeals has commented on it? Similarly, is the agent only testifying about very certain and specific cases, testifying for the government? Pull those up. You can get an idea of when the agent has testified in the past. You can pull up transcripts from those cases because you know those cases have gone up on appeal. Now, ask for lawsuits that the agent has been involved in. For the DEA manual tells us that DEA agents are required to notify their supervisors anytime a lawsuit has been filed, regardless of the outcome. Regardless of the outcome. That means that the DEA supervisors know they must have a database, but they at least know whether their agent has been involved in a lawsuit. And you can pull the papers from that lawsuit. And the last thing is find prior case testimony. Send out emails to people on listservs to find out when that agent has testified in prior cases. Pull up all of their prior case testimony if you can, and make sure you have it so that you're prepared.
I had an example in a case that I tried a couple of years ago in a threatening a federal officer case where the information I found in the agent's bankruptcy file was just priceless to me. I found out that the agent, at the time that this supposed threat had occurred, was in bankruptcy, had filed a bankruptcy, and was trying to protect his house from being lost. He had huge financial problems. My theory of the case was that he had lied about the client threatening him as really a preemptive strike to his own really wrongdoing in pulling out his weapon on the client and really using an excessive show of force. Under circumstances, he should have de-escalated rather than escalating them. And the bankruptcy filing gave me the hook I needed to show how desperate he was to keep his job, to show how desperate he was to keep his salary, to show how desperate he was at the time to fight for keeping his house and overcome his debts that really were consuming him.
Now, you've got to be prepared for the government to use the agent as an expert, either as a noticed expert in the case or as a quasi-expert. And be prepared for the prosecution to try to introduce through that agent improper expert testimony. We have a citation here to the Rodriguez case. It is such a good case. If you have time to look it up. The court identifies 6 pitfalls that district court judges frequently make concerning mixed or improper expert testimony. And then beyond that, the court identifies things that the district court should do to prevent the introduction of improper expert testimony. But do case law searches. There's so much good language out there, so much concerning this particular issue. And remember, if an agent is called to the stand and testifies as an expert as well as a fact witness in your case, not having a limiting instruction and not helping the jury understand that the agent has dual roles in his testimony is plain error. It's plain error. So you've got to be on top of this to identify when an agent is doing that, when an agent is conflating expert and fact witness testimony. Now, what we have here is an expert disclosure that I recently received in a case. And this is for a DEA agent who was going to testify at a trial as an expert. And here's a little bit of background about the case. My guy was alleged to be the source for substantial amounts of drugs that were trafficked in from Mexico to the United States. Allegations were that he was the main source for methamphetamine for Southern California. About 3 or 4 days before trial, the government produced, pursuant to 702, this very basic and bare bones expert disclosure concerning a DEA agent that I never heard of before. And this is a standard form that, at least in Los Angeles, is typically produced. Now, this may be small, and I don't know if people in the back can read it. I'm going to highlight some of the important parts. They said that Special Agent Gertler was going to testify based on his training and experience concerning the modus operandi of narcotics traffickers, particularly the role and use of lookouts in the distribution of illegal narcotics. So this is a skimpy disclosure, right? But this skimpy disclosure should trigger a demand for more discovery on your part. And then they go on to say that he was going to base his opinions on his training and experience, and this is the part that I think I like the most, and his extensive experience investigating narcotics trafficking, which includes his participation in hundreds of arrests and interviews of and with narcotics users, distributors, and confidential sources, and his review of hundreds of communications between and involving narcotics distributors. And then it cites to his CV. So you can see just from this disclosure already, the prosecutor was going to use this DEA expert to self-vouch for himself when he took the stand, because he was going to testify based on his experience investigating hundreds of different cases. Basically, the letter says that this agent is going to testify about the structure, the methods of transportation and packaging, the modus operandi, the use of undercover buys, the description and prices of methamphetamine, the difference between personal and distribution amounts, which frankly were not at issue in the case anyway, coded language, and the use of multiple cell phones. No multiple cell phones were even involved in the case. But this letter essentially says that the DEA expert is going to testify about everything relating to narcotics distributions, including things that had no relevancy whatsoever to our case. He's going to testify about all of it, though.
And basically, you can see the danger, right? They're just packaging everything as guilt. Oh, this means guilt, this means guilt, this means guilt, this means guilt. So like the Rodriguez case said, the court should view this kind of testimony as suspect. The law enforcement agents are going to want to explain why their factual observations point to guilt. These are things they developed during the case investigation. It may be more suspicion and speculation than real expertise. Can well veer into profile evidence, which is basically a way of wrapping in unreliable hearsay, character evidence, bad acts, things. So you've got to be on guard for that and can clearly invade on the province of the jury. So you got to litigate these things. You got to move in advance. You got to push for discovery. You got to make motions in advance.
So again, as Marilyn just said, you need to push for comprehensive disclosures. The disclosure you just saw, that was comprehensive in that they gave notice that the agent was essentially going to testify about everything under the sun. But it really didn't give me a lot of information that I could use to cross-examine the agent. So you got to put an additional request in writing asking for more. Now, the federal criminal procedure rules on discovery of agent expert testimony require that the defendant asks for the disclosures and the discovery of expert testimony in writing. That's Federal Rule of Criminal Procedure 16G. You gotta put it in writing. If it's not in writing, you're not gonna get anything. It's as though you didn't even request it. It's gotta be in writing. Now, the government, in response, must give a written summary of any expert testimony it intends to use. The government must give the summary. Notice that this doesn't say that the expert himself must provide the summary of his anticipated testimony. Instead, it's the government. So as you saw in the letter, what you typically get is a summary by the prosecutor. The prosecutor is going to summarize for you the information that they anticipate the expert's going to testify about. Now, what good is that for you when the expert is up there on the stand and you're crossing them? You can't cross the expert based on a summary that the prosecutor put together. Demands that the prosecutor ask the expert to put down in writing, a summary of what that expert's going to testify about. And the summary must, absolutely must, describe the opinions, the basis and reasons for those witnesses' opinions, and the qualifications. That's all of the information that you need, not all of it, that is the minimum information you need to effectively cross-examine an expert.
But we don't want you to be satisfied with that. We want you to push for what the civil folks get. If any of you in this room do civil litigation under the federal rules, you'll know that you get much more about experts. The reason why you should push for this is because the federal judges know that that's what's fair. They know it because they do it all the time, and because they're seeing all the time in civil cases the power of experts. So what do they get that we don't get? First of all, they get the stuff way ahead of time. They get it on a schedule months in advance. They get depositions that are up to 7 hours long. They get written reports in advance stating very particularly the opinions, very particularly the facts that they're based on. The federal rule of civil procedure, that's the expert rule in those cases, is 26. And if you look at 2B, you'll see what people are entitled to with expert reports. And essentially, it's a much more complete statement. When you make your discovery demands, just go look at the rule and demand what they get. I want to make sure that we get through the presentation, so I'm not going to go through all the categories of the slides, but amongst other things that they get lists of prior testimony, they get publications over several years. Don't settle for what we get in criminal cases. On Monday, I'm going to a conference with a bunch of judges in Washington, D.C., who are on the Rules Committee, and they're talking about changing Rule 16 to be more like Rule 26. So be ahead of it. These judges around the country, they know these things are happening, and they already do it in civil cases. So push for it.
And if you don't get what you ask for, after you've asked for it in writing, file motions. What we're about to show you is an example of a motion filed in a federal drug and guns case where the government gave its pretty standard expert disclosure saying that the expert's going to testify about everything under the sun, but really not providing you a whole lot of information concerning the basis for that testimony or really what that testimony is going to involve.
So the motion gets filed, and what did it ask for?
So the motion looks to exclude the expert for insufficient notice. Remember, in the civil context, you get months' notice of the expert and the expert testimony, right? In criminal cases, by contrast, we're lucky if we get the expert disclosure a week or two before trial. Usually it's just a couple of days before trial. So object for insufficient notice regarding timing, because how in the world are you going to get the information you need to properly cross-examine that expert with such little notice? How are you going to, in that short period of time, get your own expert if you need one? But also insufficient notice because the expert disclosures that are standardly given in federal case don't provide you with the information that you need to cross-examine the expert. And then move to exclude under Federal Rule of Evidence 402 and 403 as either irrelevant or prejudicial, right? In the case that you saw just a few minutes ago, what in the world does multiple cell phone use, what did that have, what relevancy did that have in my case where there was no evidence that my guy, the only defendant going to trial, used multiple cell phones? Who cares whether an organization uses lookouts if my guy was alleged to be the source of the drugs, right? What relevancy did it have to the issues that were going to go in front of the jury? Aside from being just prejudicial and frankly irrelevant. And then lastly, preclude expert testimony as exceeding the proper scope of opinion testimony under 702, 703, and 704. Don't let the prosecution use the expert as a way to circumvent the jury and tell the jury that the facts of your case mean guilt, because that's what they're going to try to do. They're going to get the expert on the stand to say, listen, I've done hundreds of cases. I know when a person has been involved in drug trafficking. I've looked at this case and I know that that person has been involved in drug trafficking. Don't let them do that, because that's what they're going to try to do unless you move to preclude it.
So we've pretty much covered the next few slides. Basically, you need enough to be prepared, to make your motions, to hire your own experts and prepare for cross. Do not think that boilerplate's enough. The courts recognize boilerplate disclosures aren't enough. Be prepared to know that bad act evidence is going to be tried to be snuck in through an agent who is a so-called expert. And then, Meghan, if all else fails?
If all else fails and the government has gotten in all of this terrible expert testimony, it's already in front of the jury. Ask for a limiting instruction. In United States versus Thomas, the court said it must take care to assure that the jury is informed of the dual roles of a law enforcement officer as a fact witness and as an expert witness, so the jury can give proper weight to each type of testimony. And remember, it is plain error for a court not to give a limiting instruction if an agent testifies as both a fact witness and also as an expert witness. Plain error. The Ninth Circuit has model jury instructions that are okay, that deal with this. The notes to the model jury instructions, though, point to a number of cases that were overturned on appeal, where the government failed to, where the court failed to give the limiting instruction. But then the notes go beyond that and say in some cases, it may be appropriate for the court to order the government to draw out fact testimony separately from expert testimony so that it's clear to the jurors when the expert is testifying as a recipient fact witness and when the expert puts on his expert hat and testifies as an expert witness. And the Rodriguez case that we discussed briefly earlier also provides a caution on that and suggests that if there is a conflation of that evidence, that the prosecutor should go through and identify for the jury which information was elicited in the context of a fact witness and which information was elicited as an expert witness.
So basically, after all this preparation, you're going to be so enabled and so able to point out that that agent is on the team and is so biased and is just looking for a conviction and not the truth. And so we have this to end with.
And here we have a funny comic of a judge, the defense attorney, and the witness on the stand who was just subjected to a really brutal cross. And the attorney says, "I'd like to request a brief recess, Your Honor, as the witness's pants appear to be on fire."
Thank you.